another half-century before African Americans could enjoy the full rights of citizenship. It took mighty movements and decades of fraught political conflict to achieve even those basic dignities and establish the United States as a full democracy worthy of the title. Progress in the right to vote is a hallmark of this democracy. When the nation was founded, you had to be a white male Protestant property owner in many of the states. So a very small percent, if we kept those rules into effect, let's not change things, we maybe would have 5% or 10% of the American people voting. But no, our move to equality, our move to fairness has been inexorable. But it didn't happen on its own. It took mighty movements and decades of fraught political conflict to achieve those basic dignities and establish the United States, as I said, as a full democracy worthy of the title. But any American who thinks that the fight for a full and fair democracy is over is sadly and sorely mistaken. Today, now, in the 21st century, there is a concerted, nationwide effort to limit the right of American citizens to vote and to truly have a voice in their own government. In the wake of the November elections, one of the safest in recent history, Republican-led state legislatures have seized on the former president's big lie that the election was stolen and introduced more than 250 bills in 43 states aimed at tightening voting rules under the guise of election integrity. Instead of doing what you should be doing when you lose an election in a democracy, attempting to win over those voters in the next election, Republicans instead are trying to disenfranchise those voters. Shame on them. In Iowa, where college students often rely on the flexibility provided by early and mail-in voting, the Republican legislature voted to cut early voting by 9 days, close polls an hour earlier, and tighten rules on absentee voting. In Wisconsin, where urban and rural precincts face vastly different administrative burdens, Republicans have proposed limiting ballot drop boxes to only one municipality, no matter what its size. Could be 10,000 voters in a rural Republican county or 500,000 voters in an urban Democratic county, one ballot drop box. In Arizona, no fewer than 22 separate measures to limit voting rights have been introduced, including a bill to require every absentee ballot to be notarized. How are poor people going to pay for a notary when there's virtually no indication of fraud? It's one of the most despicable things I have seen in all my years. Shame, shame, shame. Other things in Arizona? 2 bills to ban automatic voter registration and same-day registration, even though neither practice exists in Arizona. And the most reprehensible effort of all might be found in Georgia, where Republicans recently passed a bill to eliminate early voting on Sunday, a day when many church-going African Americans participate in voter drives known as Souls to the Polls. What an astonishing coincidence. Outlaw voting on a day when African American churches sponsor get-out-the-vote efforts. I'd like one of the Republican members on this committee to give us a plain-sense justification for that restriction. No early voting on Sundays. Why did Georgia Republicans outlaw it? Monday through Saturday, legitimate voters show up. But Sunday is voter fraud day. Give me a break. Every one of us, Democrat, Republican, liberal, and conservative, knows what the Georgia legislature is doing. They don't even have a good justification for it. This is infuriating. I would like to ask my Republican colleagues, why are you so afraid of democracy? Why, instead of trying to win voters over that you lost in the last election, are you trying to prevent them from voting? Our country has come a long way, supposedly, since African Americans in the South were forced to guess the number of jelly beans in a jar in order to vote. But some of these voter suppression laws in Georgia and other Republican states smack of Jim Crow rearing its ugly head once again. It is 160 years since the 13th, 14th, and 15th Amendments abolished slavery, and Jim Crow still seems to be with us. The laws, their various cousins in Republican state legislatures across the country, are one of the greatest threats we have to modern democracy in America. According to the Washington Post, these laws could strain every available method of voting for tens of millions of Americans, the most sweeping contradiction of ballot access in the United States since the end of Reconstruction. If one political party believes that when you lose an election, the answer isn't to win more votes, but rather to try and prevent the other side from voting, we have an existential threat to democracy on our hands. If we don't stop these vicious and often racist actions, third world autocracy like Erdogan's Turkey or Orban's Hungary will be on its way. That is why the country so badly needs S1, a bill that would combat all of these voter suppression efforts, a bill that would make it easier, not harder, to vote by automatically registering American voters when they get a driver's license, by guaranteeing at least 15 continuous days of early voting, a bill that would limit dark money and corruption in our politics, and much more. We're going to hear from my fellow Democratic committee members why the bill is so important. And I expect we're going to hear the same tired canards from our Republican colleagues, many of which have no basis in fact, most of which defy belief. We're going to hear that this bill, gasp, register Americans to vote, is a Democratic power grab. We're going to hear that it's a federal takeover of our elections. Never mind that the founders, who my Republican colleagues invoke when it's time to confirm a right-wing judge, wrote in the Constitution, that the Congress has the power to pass laws to determine the time, place, and manner of federal elections. We've been down this road before. Opponents of voting rights throughout history have always said, leave it to the states. Just leave it to the states to discriminate against African Americans, Latinos, Native Americans, younger Americans in college. It is shameful our Republican colleagues are proposing these ideas in 2020, the same kinds of states' rights that have been used from time immemorial to prevent certain people from voting. Shame, shame, shame. This is not an usual political argument. This goes to the core of our democracy. The crowning achievement of the American Civil Rights Movement was a federal election law. You might know it better as the Voting Rights Act. Federal, bipartisan. The truth is that we have passed scores of federal election laws and amended our Constitution to guarantee the franchise to our citizens, often bipartisan, led by Republican presidents. The Voting Rights Act of 1965, the National Voter Registration Act of 1993, the Help America Vote Act of 2002, the 14th, 15th, 19th, 23rd, 24th, and 26th Amendments, all election changes. That's because in a democracy, it shouldn't matter if a state wants to make it so onerous for a particular group to vote that it's nigh impossible. Is requiring a notary public any different than asking people to guess the number of jelly beans in a jar? I guarantee you the motivation is exactly the same. It shouldn't matter if a state wants to do it, if it's so wrong, so against the grain of our democracy. Voting rights are sacrosanct. They must be inviolable. And if Congress has to pass a law or amend the Constitution to protect the voting rights of our citizens, that's what we should do. That's what we must do. That's what our democracy requires we do. S1, the For the People Act, will be a priority in this Congress. Thank you.
Thank you very much, Senator Schumer. We now turn to the Republican leader, Senator McConnell.
On what the majority leader has just said, the state bills that he refers to, I believe Senator Blunt has mentioned only 2 of them have passed, and they had absolutely nothing to do with suppressing the vote. It's also noteworthy that this is a solution in search of a problem. The turnout in 2020 was up 7%. The turnout in the 2020 election was the highest since 1900. States are not engaging in trying to suppress voters whatsoever. This is clearly an effort by one party to rewrite the rules of our political system. But even more immediately, it would create an implementation nightmare, as Senator Blunt pointed out, that would drown state and local officials who run elections. This proposal needs all the scrutiny it can get, and I'm glad we're all here to give it that scrutiny. This legislation would forcibly rewrite the election laws of all 50 states from here in Washington. Popular policies like voter ID requirements would be banned unless states neutered them with loopholes. Meanwhile, unpopular and absurd practices like ballot harvesting, where paid political operatives can show up carrying stacks of other people's ballots, would not just be allowed, it would be mandatory. Washington would mandate that every state and county in America adopt same-day voter registration with minimal safeguards. But it would make it incredibly difficult for states and counties to conduct routine voter list maintenance, like removing dead people or voters who don't live there any longer. Then there's the whole question of political speech. Refereeing campaigns and policing speech are sensitive tasks. Appropriately, the FEC was designed after Watergate to be bipartisan, an even split, 3-3. So let me dwell on that for a minute. After Watergate, my party, the Republican Party, was just about wiped out. The overwhelming Democratic majorities could have done anything they wanted to. It never occurred to them that the Federal Election Commission, set up to police how we run campaigns, would be made a partisan entity. They could have done it then. Now we're in a 50-50 Senate and a narrowly majority in the House. And this audacious move wants to turn the judge of our democratic process into a partisan prosecutor. Talk about shame. If anybody ought to be feeling any shame around here, it's turning the FEC into a partisan prosecutor, the majority controlled by the president's party, to harass and intimidate the other side. That's what you ought to be ashamed about. Over in the House administration, we're having, in an administration committee, we're having an example right now of how that could happen. The Democratic majority is trying to overturn a certified election result. I want to ask how many of our friends on the other side here were just arguing last month and the month before that certifying a state election was the gold standard. It's over after certification. Apparently not in the House. Of course, the Constitution gives the House to determine who will sit there. That doesn't mean they should go against everything they were preaching in the last 2 months about the sanctity of state certification and simply ram through someone who lost the election, according to officials in Iowa. That's what happens I would say to my Democratic friends, that's what happens when you let partisan bodies regulate elections. And that is certainly not what we need at the FEC. And that's what, among other things, you ought to be ashamed about. This bill would also expand the scope of this newly partisan FEC. More power over more of America's speech, more mandates for private groups to publicize their list of supporters. Associational privacy is a core liberty. It's been championed heroically by organizations like the NAACP. This bill is such an attack on citizens' privacy that even the left-wing ACLU opposes this bill. These are big-picture problems. But on a practical level, even if you disagree with everything I just said, the fact is, as Senator Blunt pointed out, this legislation is just not ready for prime time. It's an invitation to chaos. Chaos. State-level election officials, including Democrats, are sounding alarms left and right. This messaging bill would create a nightmare if it actually became law. It would mandate brand new voting machines that have not even been produced yet. It mandates something that doesn't exist, let alone certified and approved. It would force every state to rush through big changes like inventing new, unsecure, automated telephone systems to register voters. I'm sure prank callers would have a field day with that. This thing even has something to say about the paper on which local officials would be able to print their ballots and the kind of envelope adhesive they have to use. And that's a really important thing for the federal government to dictate. What kind of adhesive they have to use. What a great idea. Just the prospect of all these silly new mandates is already keeping local officials up at night, and that includes, by the way, Democratic local officials who conduct elections. And of course, this thing would even put American taxpayers on the hook for transfer payments. Don't be kidded into thinking there's not federal money in this bill. Transfer payments that would go directly to fund political campaigns. Taxpayer-funded bumper stickers and attack ads. What a great idea. American people are really going to like that. Taking their money and spending it on attack ads, bumper stickers, buttons, and balloons. Look, even liberals who like this bill better than I do are admitting all the practicalities need to go back to the drawing board. This is nowhere near ready for prime time. It's an invitation to total chaos. So I'll close with this. Senator Klobuchar, I had your job after the 2000 election. Chris Dodd and I teamed up to pass the Help America Vote Act. It was a major voting bill. What it did was to try to encourage making it easier to vote but harder to cheat. It was a combination of things. Well balanced. It passed 92 to 2. 92 to 2. That's the kind of consensus that can be built when you approach a subject like the one that's before us today in the right way. By contrast, this bill did not receive a single vote in the House, and I predict it will not in the Senate, should we unfortunately have to vote on it. Both Republicans and Democrats voted against it in the House. Now, we've just seen two consecutive presidential elections, 2016 and 2020, where chunks of Americans on both the left and the right took turns refusing to accept the result when their side lost. We can't afford to go further down this road. We should be finding ways to rebuild trust, not destroy it further. But that's exactly what a partisan power grab would guarantee. And that's what S1 is all about. Thank you, Madam Chair.
Thank you very much, Senator McConnell. I do want to clarify that the bill did pass the House, did receive votes in the House, 220 to 210, with only one Democrat voting against the bill. By a prior agreement, Senator Merkley, who's the author of the bill, is going to say a few words, and then we'll introduce the witnesses. Thank you.
Thank you, Madam Chair. And this is clearly a very important conversation for our country. It has been since we were born. Our founders had this revolutionary idea that instead of power flowing down from kings and being edicts on the people, it would flow up from the people to guide our nation in its current time and in times to come. That power is exercised through the ballot box, which makes that ballot box an incredibly important, not just a symbol of government by the people, but the core device through which that power is exercised. Our founders recognized that this could be difficult. And I think you have all heard that Ben Franklin in 1787, when he was leaving the Constitutional Convention, exiting the door of Independence Hall, was asked, "Doctor, what have we got, a republic or a monarchy?" And he replied, "A republic if you can keep it." And this battle over keeping the vision of our country, of power flowing up from the people, has been one that we have had to fight to maintain throughout our history. It was Lincoln who he was speaking at Gettysburg, commented on the fact that we here highly resolve that these dead shall not have died in vain, that government of the people, by the people, for the people, shall not perish from the earth. Now, our founding document was flawed in that it didn't give the power of the ballot box, the power of the vote to every individual, and we have worked through great struggle to make sure that that is remedied. Through the 14th and 15th Amendment, we overcame some of the barriers on race. Through the 19th Amendment, barriers on gender happening within the lifetime of my father, I was astounded to learn as a child. Overcoming barriers that denied Native Americans the right to vote with the Indian Citizenship Act of 1924. Overcoming barriers of Jim Crow and the Voting Rights Act of 1965. LBJ, commenting at that time, said the vote is the most powerful instrument ever devised for breaking down injustice. And many have characterized the power to vote as the most fundamental right. Robert Kennedy famously saying, "Each citizen's right to vote is fundamental to all the other rights of citizenship." So here we are now, once again, struggling with the battle on how to defend the integrity of our election process, the integrity of the ballot box. We have elections that are afflicted by gerrymandering, which is a direct attack on equal representation. Political scientists continue to tell us that the representation in the House of Representatives is significantly biased by the gerrymandering that takes place in various states. Every American has a stake in the integrity of eliminating gerrymandering. The dark money flowing through our campaigns, the big money, is a source of such cynicism to Americans that this unidentified, massive, hundreds of millions of dollars is drowning out their voice. They see those campaign attack ads, hundreds and hundreds of millions of dollars, nobody knowing where this money comes from, and what they know is that isn't power from the people, because people don't have hundreds of millions of dollars. That is power from the corporations. That is power from the mega rich attempting to influence the course of our country, not for the people, not of, by, and for the people, but of, by, and for the powerful. We have a responsibility to address that. And then voter suppression. Well, this is not some, as I just heard, some silly idea that we should stop voter suppression. It is fundamental. We took an oath to the Constitution, and that involves defending the right to vote, defending the ballot box. And we are going to see a lot of laws passed trying to take that away. We all know how easy it is to manipulate the vote on Election Day. We know because we see it. We see the long lines in very poor communities. We see difficult places to reach or moved precinct polling places in areas that are primarily where Black Americans vote. We see the false information put out by various characters saying, oh, the election was last week, sorry you missed it, when actually the election is a coming week. Or saying, here's the place to vote, but it's not the accurate. And so the antidote to the manipulation of Election Day has been to enable people to vote early or vote by mail. It's worked in red states like Utah. It's worked in blue states like Oregon. It has been popular with citizens who want to know that they can exercise their right without being sent to the wrong place, without being sent to some place that has no parking, without being sent to some place where there's no staff so they have to wait in line for 5 hours, without worrying about whether that November election is in the middle of a snowstorm. They want to exercise that right, and we have a responsibility to defend their ability to do so. So let's take on these afflictions in a bipartisan manner. Until recently, it was bipartisan energy in support of the vision of election integrity. Let's summon that spirit together again. Let's summon the spirit that led us to the 14th and 15th Amendments, the 19th Amendment, that led us to the 1924 Indian Citizenship Act, that led us to the 1965 Voting Rights Act. It is our responsibility, and it's imperative that we act, and we act now. Thank you, Madam Chair.
Thank you very much, Senator Merkley. Before we swear in our first panel of witnesses today, I'd like to make a motion to enter into the record some documents by unanimous consent. They were submitted by national leaders, civil rights groups, democracy reform groups, and others in support of S1, the For the People Act. I'd like to highlight 3 letters in the group. The first from former First Lady Michelle Obama's organization, When We All Vote, in support of the bill, which has been signed by more than 60 people who are national leading voices in the arts, sports, and civil rights, including Tom Hanks, Kerry Washington, Lin-Manuel Miranda, and Issa Rae. A letter from the Declaration for American Democracy in support of the bill that has been signed by more than 300 national and state organizations, and a letter from the National Disability Rights Network, which highlights some of the challenges voters with disabilities continue to face when casting their ballot and emphasizes the urgent need to enact many of the reforms in the For the People Act. As unanimous consent to put these letters in the record? Put them in the record. I'm now going to introduce 3 of the witnesses, and Senator Blunt will introduce the other witnesses, the other 2 witnesses, including one that's with us today. But before we do that, I'll swear in the witnesses. If the witnesses could please stand, including those joining us virtually, and raise your right hand. Do you swear that the testimony you will give before the committee shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Thank you. Now our witnesses. Our first witness today is former U.S. Attorney General Eric Holder. Attorney General Holder began his career in public service in the Public Integrity Section of the Justice Department in 1976. He was later appointed by President Reagan to serve as a judge on the Superior Court of the District of Columbia in 1988. After Attorney General Holder stepped down from the bench in 1993, he made history as the first African American to serve as the U.S. Attorney for the District of Columbia. In 1997, he was named Deputy Attorney General by President Clinton and became the first African American to serve in that position. He then moved on to a law firm at Covington and Burling, and after that, in 2009, he again made history by becoming the first African American to serve as U.S. Attorney General under President Obama. In 2017, he launched the National Democratic Redistricting Committee and has served as its chair. Our second witness today is Secretary Jocelyn Benson. Secretary Benson was elected as Michigan's 43rd Secretary of State in 2018. Over the last 2 years, she has implemented a number of major reforms, and this is very important to the discussion we will be having today about the implementation issues. She has been able to do this with no issues to Michigan's elections, including putting in place automatic voter registration, same-day registration, and no excuse vote by mail for all voters, as well as conducting post-election audits. Before taking office, she was the youngest woman in U.S. history to lead a top 100 accredited law school after she was appointed as the dean of Wayne State University Law School in Detroit at the age of 36. Previously, she was an associate professor and associate director of Wayne Law's Damon J. Keith Center for Civil Rights. She also currently serves as vice chair of the advisory board for the Levin Center at Wayne Law, which she founded with former U.S. Senator Carl Levin. Secretary Benson received her BA from Wellesley University, her MA from Magdalen College at the University of Oxford, and her law degree from Harvard Law School. Our third witness on the first panel is Mr. Michael Waldman, president of the Brennan Center for Justice at New York University Law School. He has served in that capacity since 2005. He began his career in 1989 as the director of Public Citizens Congress Watch. From 93 to 95, he served as a special assistant to President Clinton for policy coordination and was the top White House aide on campaign reform. He then continued to serve in the Clinton administration as director of speechwriting and assistant to the president until 1999. He has written 4 State of the Union addresses and 2 inaugural addresses. Mr. Waldman has also been a lecturer in public policy at Harvard's John F. Kennedy School of Government and practiced law in Washington, D.C. and New York. He received his BA from Columbia University and his law degree from NYU School of Law. And I'll now turn it over to Senator Blunt to introduce the 2 other witnesses.
Thank you, Senator Klobuchar. Since you responded to Senator McConnell's comments, I have just one brief comment to what Senator Schumer had to say. He said he'd like for any Republican to answer the question of why Georgia should eliminate voting on Sunday. They are not eliminating voting on Sunday. It did not pass the legislature. The Republican governor, even the Republican lieutenant governor, even refused to preside over the debate. This is an idea like most of the 253 ideas out there introduced by some Republican in some legislature somewhere that will not happen. You know, we can spend all day talking about legislation that was filed by Republicans that will not become law, or we can talk about this bill. And I hope we get to where we talk about this bill. I have 2 witnesses today we've asked who can talk about this bill with great knowledge of how this bill will affect states. One of our witnesses, Todd Rokita, was elected to serve as the Attorney General of Indiana in November of 2020. Prior to that, Todd Rokita served Indiana in the Congress and as Indiana's Secretary of State. Todd was elected as president of the National Association of Secretaries of State in 2007. Our second witness today, Mac Warner, is West Virginia's 30th Secretary of State. He graduated from the United States Military Academy at West Point and the West Virginia University School of Law. Prior to serving as Secretary of State, he served his country for 23 years in the United States Army and 5 years in Afghanistan with the State Department. And I'd like to turn to Senator Capito for any additional comments she might make about her Secretary of State, Mac Warner.
Well, thank you, Senator Blunt. Thank all of you, and I want to thank our Secretary of State, Mac Warner, for joining us today. He ran a flawless election in 2020 under difficult situations for everybody. We had more people voting. We had no disputes to speak of. And I want to thank our Secretary of State for not only being a leader in this area on mobile voting as well, but also for serving our country. He comes from a long line of West Virginians, and I'm proud to have him here with us today. Thank you.
Very good. We'll start with our first witness. The witnesses have 5 minutes for an opening statement, and we will begin with Attorney General Holder.
Thank you. Chairman Klobuchar, Ranking Member Blunt, and members of the committee, I want to thank you for the opportunity to appear before you today. You know, for as long as this country has existed, there have been two opposing forces that have fought over how we define and confer the rights and privileges of citizenship, freedom, and equality. Every step that has brought us closer to universal suffrage has been met by those, often by those who are in power, who want to maintain an unjust status quo. Much in the same way that Reconstruction was followed by the era of Jim Crow, the progress won by the Civil Rights Movement, including the Voting Rights Act of 1965, has faced a multi-pronged assault that has sought to take us back to an era in which politicians, not the people, pick who wins and consequently who can participate in elections. The events of the past few months have brought into stark focus what has been true for too long. There is a large and powerful faction in this country intent on retaining power and who will bend or break the rules of our democracy in order to do so. The attack on our system of government did not begin or end with the insurrection at the Capitol on January the 6th. For years now, politicians have spread the same lies about voter fraud and advanced falsehoods about the integrity of our electoral system. The fact is that there is no evidence of widespread or systemic fraud during the 2020 election or at any other time. Yet state legislators around the country have used these baseless assertions as a pretext to introduce, as we've heard, more than 250 bills in 43 states that would restrict who can vote. This new wave of bills is the latest step in a decade-long project to systematically chip away or outright eliminate key protections for voters in a way that has undermined our representative democracy. Too many Americans, and particularly people of color, face discriminatory and onerous barriers to vote. The For the People Act is a necessary and appropriate response to both the erosion of voting rights and the advancement of special interest. The combination of unprecedented partisan gerrymandering during the 2011 redistricting process, the wave of voter suppression bills passed in the wake of the Supreme Court's disastrous Shelby County decision, and the flood of dark money unleashed by the court's Citizens United decision have all combined to create a political system that does not adequately represent the desires of the American people. The For the People Act is the right remedy at the right time. This bill recognizes that the best solution to abolishing the undemocratic trinity of issues plaguing our democracy, gerrymandering, voter suppression, dark money, is to get rid of all of them at once. By creating a baseline of protection for voters, rooting out corruption and dark money, and ending the practice of partisan gerrymandering, this Congress can create a fair, level playing field in our electoral system. This bill also makes evident that Congress should pass the John Lewis Voting Rights Advancement Act, which would update the formula for determining which jurisdictions are subject to federal pre-clearance. Now, taken together, the For the People Act and the John Lewis Voting Rights Advancement Act represent the greatest pieces of civil rights legislation since 1965 and are badly needed reforms that will strengthen our democracy. Now, despite what opponents may say, this bill would not favor either party. To the contrary, it would create a level playing field for the American people. The reality is that no matter what political party you support or what policies you advocate, your voice will be stronger if politicians are required to be responsive to your needs. Now is the time for Congress to exercise its constitutional authority to protect the structure of our representative democracy. Ensuring a true representative democracy is how we advance equality, opportunity, and justice in areas where too many Americans are still let down, left out, and left behind. It's how we make every vote count and how we make every voter count. It's making the determination of what kind of country we want to be, one closer to its founding promise, or a nation turning away from our democratic ideals. Passing this bill will be a critical and necessary step to restoring power to the people where it belongs. Thank you.
Thank you very much, Attorney General Holder. Next with us today, Secretary Andrew McWarner from West Virginia.
Thank you, Chairwoman Klobuchar, Ranking Member Blunt, and members of this committee. Thank you for letting me address the implications of S1 on the state of West Virginia. Dubbed For the People's Act, this is anything but for the people. In fact, it is against the people. It is against the states, and it is against the United States. First, it is against the people because it overrules access and it overrules checks and balances. My most vehement objection to this is that by prohibiting electronic transmission of ballots, it strips the most efficient and secure form of voting for our military, the people who put their very lives on the line for our democracy and way of life. When I was deployed, as were my two sons, my two daughters, my two sons-in-law, all of whom served in the U.S. Army, it is prohibited. They have had difficulty voting. Therefore, when I became Secretary of State, I determined to fix this, and we did it through electronic transmission of ballots using mobile devices. We proved the technology with our military, and then we extended it to voters with disabilities, giving them not just the right to vote, but the opportunity to vote. 31 states allow electronic transmission, and S1 strips this opportunity for everyone to vote electronically. How is this for the people? Clearly, it's not. S1 also overrules checks and balances in our election security. It mandates AVR, including 16-year-olds. It bans ID laws and shields non-citizens from prosecution. It eliminates signature verification. It pushes mail-in voting without photo ID. It promotes ballot harvesting and requires drop boxes. It delays election results by requiring acceptance of ballots up to 10 days. That delay and all of these collectively decrease individual confidence, and it increases distrust in our elections. Second, S1 is against the states because it requires a huge expansion of state legislation and imposes funding mandates far beyond states' abilities to implement. It forces decertification of every voting machine in West Virginia, wasting tens of millions of dollars that you've provided to us through HAVA funding. It mandates same-day registration, which requires poll books connected to the internet through high-speed broadband, something West Virginia simply cannot do. We do not have high-speed broadband in all the precincts of West Virginia. It requires agencies beyond DMV, such as colleges and social services, to automatically register people that come in contact with them and transmit their personal identification information, thereby increasing risks for hackers, and it busts our budgets. It forces election officials to accept and count ballots voted in incorrect precincts. It stops states from cleaning up voter registration lists, and West Virginia's Clerk Association President Linda Huggins said this: "Clerks are unanimously against S1 because deadlines cannot be met and requirements are not achievable." Clerk Michelle Hawley cited unfunded mandates as showstoppers, and Clerk Brian Wood said, "It doesn't matter if you're Democrat or Republican, if you want to keep our democracy intact, you've got to leave it up to states to run their elections." To implement the changes by January 1st, a special session of our legislature would be required, which is not practical and would be hugely expensive. In sum, take away the ideology and the partisanship. Clerks across West Virginia, most of whom I'm told are Democrats, are against S1. Third, S1 is a vast federal overreach. This 800-page monstrosity stomps on states' rights. The U.S. Constitution does say that the time, place, and manner of elections shall be prescribed by state legislatures. States have individual approaches based on history, geography, and cultures that create vastly complex and different election processes. This broad mosaic provides election security versus a one-size-fits-all approach. The private right of action remedy is tremendously problematic, as are the number of severability clauses that indicate S1 is not likely to withstand judicial scrutiny. The court cases will increase delays, cause confusion and distrust in our already contentious and tense election process. In conclusion, S1 is not for the people, especially not for the people of West Virginia. Federalizing elections has never been done before, and for good reason. Senators, please leave election administration up to the states. The impossible requirements and unfunded mandates of S1 will create election chaos and further divide our country. On behalf of the state of West Virginia, as its chief elections official, I urge you to consider these grave implications, and I thank you for this opportunity to bring these various serious flaws and concerns to your consideration. Thank you.
Thank you. And for a different perspective on the bill, the Secretary of State for the state of Michigan, Jocelyn Benson.
The election of 2020 is behind us. The war on democracy is escalating. And in addition to the ongoing efforts of democracy deniers to spread misinformation alongside continued attacks and threats against election officials, a new battlefront has emerged in state legislatures all across the country. Yet Michigan's story demonstrates a different path. Our experience underscores that voters on both sides of the aisle want reforms like those in the For the People Act. And it shows how, with sufficient funding, partnerships, leadership, and political will, it is entirely possible to efficiently and successfully implement those reforms. In November 2018, Michigan citizens voted overwhelmingly to amend our state constitution to instill the right to vote absentee without a reason, same-day voter registration, automatic voter registration, and an independent citizens redistricting commission. My office was charged with working with 1,600 clerks all across our state to implement all of these policies in advance of the 2020 election cycle. And we did, because these policies are not new, and implementing them is not rocket science. And many states already have these reforms in place. We conferred with leaders in those states to learn from their experience, replicate best practices, and modernize our democracy effectively and efficiently. We implemented automatic voter registration, for example, with security protocols in place to ensure that only eligible citizens were registered. By November 2020, we increased our number of registered voters by 250,000. We found that voters on both sides of the aisle embraced the ability to vote absentee and use secure drop boxes to return their ballots. The number of people voting absentee in Michigan increased exponentially from 1.1 million in November 2016 to 3.3 million in November 2020. And we saw thousands of new voters register in the days leading up to the November election, including 30,000 on election day itself, and the majority of those were under 30. In the end, due in no small part to these reforms, we had the most successful, secure election in our state's history. We've also succeeded in implementing Michigan's first independent citizens redistricting commission, enacted by voters in 2018. We found that when given the chance, citizens embrace the opportunity to draw their own legislative districts. The commission is already at work, and you can learn more about their work at redistrictingmichigan.org. Now, if Michigan can do all of this in one election cycle, in the midst of a global pandemic and during one of the most significant and highly scrutinized election cycles in our lifetime, every state in the country, with proper funding and leadership, can do the same. Because while states are laboratories of our democracy, federal minimum standards ensure equal protection of every citizen's right to vote. And yes, every state will face unique circumstances in incorporating a new federal floor, but it's our job to meet those challenges, not to shirk them. Just as the National Voter Registration Act took a popular state policy in Michigan, the motor voter law, and made it a nationwide convenience for every citizen, it will take collaboration, partnerships, leadership, and funding. But it can be done. Truly, only politics and political will stands in our way. I want to close by noting that 56 years ago, at this very moment, thousands were marching from Montgomery to Montgomery, Alabama, from Selma, to similarly call on their federal government to protect their right to vote against the efforts of states to impede their access. Many of those brave advocates were beaten, some lost their lives. But their work led to the passage of the Voting Rights Act, one of the most effective voting laws in our nation's history. When it was proposed, it was met by many of the same attacks and critiques that we hear today. Opponents said compliance would be impossible, that it would be an overreach of federal authority. But in the years that followed, those critics were proved wrong, and our nation became a more perfect union as a result. So clearly, history instructs and the current moment demands that we once again step in and defend democracy. At this moment, you are our greatest hope, and this legislation is our best chance to stop this rollback on voting rights that is sweeping state legislatures throughout the country. I urge you to act and advance this legislation because no matter where a voter lives or who they vote for, their right to vote should be protected. The future of our democracy depends on your leadership today. Thank you.
Thank you very much, Secretary Benson. The next witness is Attorney General Todd Rokita. Thank you for being with us.
Thank you, Chairwoman, Ranking Member. Appreciate you inviting me to speak today on behalf of the citizens of Indiana. My name is Todd Rokita, and I serve as the Attorney General for the state of Indiana. And prior to serving as and prior to that, I served as Indiana's Chief Election Officer, as well as a member of Congress. Given my experience as Indiana's chief election officer and in various offices, I know how elections can and should be run to ensure transparency and public confidence in elections. And we don't hear enough about the need for public confidence in our elections in order to make this republic work. Any effort to address America's election system must begin with recognition of a simple fact: the 2020 presidential election was unlike any other in our history, and it doesn't need to be repeated because we shouldn't be having pandemics every time we have a presidential election. The 2020 election involved an effort to convert what has traditionally been election day in our country to a months-long process of vote gathering, ballot harvesting, last-minute rule and law changes by people not authorized to do so. And all this resulted in shaken confidence in our electoral system and a profound unease, if not outright distrust, about the results. Americans saw mountains of mail-in ballots being processed in cavernous central count processing centers, tens of millions of mail-in ballots overloading the processing capacity of the system in many states, turning the tabulation of votes into a weeks-long process. And in case after case, we saw vote watchers and observers excluded from an opaque, seemingly never-ending counting process. Many of the problems of 2020 resulted from the efforts of those without the authority to do so, trying to control how the election was run and changing election rules at the last minute. This led to an unprecedented number of election lawsuits that frankly have overwhelmed the system. Senate Bill 1 would increase the number of those lawsuits, both against states and states suing the federal government. The mandates of this bill are wholly unnecessary, and the determinations for how elections are operated should remain with the states, as intended by the framers for good reason. The proposed changes will open our elections up to increased voter fraud and irregularities, and promote perhaps the most egregious provision is the Act's elimination of voter and photo ID laws. Requiring government-issued photo ID at the polls represents a common-sense, simple best practice for election administration, and it is in place in over 32 states. Government-issued photo ID has been the global standard for documentary identification purposes for decades. I recently talked with a Hoosier who had dual citizenship. She was an American citizen and she is a Mexican citizen. She showed me her voting card, a specially issued card just for voting, that not only had her picture, but a copy of her thumb fingerprint that was compared at the voting booth when she had to use it, had to dip her thumb in ink and use it to compare. Now, this is Mexico, by many a third world country that has better turnout than we do, upholding the integrity of one citizen, one vote there. And here, this bill making a lot lower standard than that illegal. We're going in the opposite direction for a free society. Regardless of which party or candidate a voter favors, all Americans should have confidence in the outcomes of their elections. No American's vote should be devalued by fraudulent votes. Earlier this month, 19 of my Attorney General colleagues joined me in a letter to your leadership opposing H.R. 1, similar to S1. As we wrote in the letter, the Act has several constitutional deficiencies and mandates that, if passed, would federalize state elections and impose burdensome costs and regulations on state and local officials. The measures proposed in S1 turn our constitutional election structure on its head. They would open the door for greater fraud and less confidence. Our system of government depends on the electorate having faith in the outcome of our elections. Removing voter integrity measures such as photo ID laws, requiring votes to be counted up to 10 days after the election, requiring that unaccountable commissions and DC judges far removed from the states should draw our district lines, isn't going to solve any of that. It's going to make the situation worse. Voters should have a voice through their directly elected representatives in their states and how these elections should be run. While the bill pretends to apply only to federal elections, the simple fact is these changes will apply across the board because no state can afford to have separate elections for state elections and federal ones. States should continue to hold elections in a manner that best suits each state, and S1 would take control entirely away from the states. Simply put, if states are laboratories, and that's what our founders intended, and that's what's been proven time and time again, the passage of S1 would make the states' laboratories closed. and no innovation would occur. Should the act become law, I could tell you the sun won't set in Indiana before we sue the federal government, and I'm sure other states will join. Thank you for your time.
Thank you. Next, for our final witness, Michael Waldman, the president of the Brennan Center for Justice.
Thank you, Madam Chairwoman, Ranking Member Blunt, and members of the committee. Thank you for the opportunity to testify on behalf of this landmark legislation. We believe the For the People Act, S1, would be the most significant democracy reform measure in over half a century. It is the next great civil rights bill and responds to the demand for racial justice in our country. It is long overdue, and it is urgently needed now. Now, as you know, there are a number of reforms in this legislation relating to curbing the role of money in politics, to dealing with gerrymandering, to dealing with ethics. I want to focus on the sacred right to vote, which is in so many ways at the heart of our democracy and our understanding of ourselves as Americans. And I ask you to think about what happened in 2020. Despite the pandemic, despite voter suppression, despite the lies, it was the highest voter turnout since 1900. And as has been said, the Trump administration's own Department of Homeland Security confirmed it was the most secure election ever. This is something we ought to celebrate. Instead, what has happened? We had the big lie about the election being stolen. We had the insurrection driven by that big lie. And now in states across the country, a wave of legislative attempts to curb the vote, the most significant attempted cutback in voting rights since the Jim Crow era. The Brennan Center has studied these laws for years and found, as has been mentioned, 253 laws that would, in one way or another, cut back on voting. That was last month. 7 times higher than the rate 4 years ago, and the number is actually higher right now. These laws are being pushed hard. It is only March, I should note, and already the governor of Iowa has signed into law significant cutbacks, for example, in vote by mail. In Georgia, the legislature is finishing its work this week on an egregious bill. There was a public outcry that has forced changes, but there are still tremendously harmful provisions that will be moving through the legislature. These laws that we see across the country affect voters of color, young voters, poor voters. And the intent, I'm afraid, is often unambiguous. One of the sponsors of these bills in Arizona said the purpose was to make sure that only, quote, quality voters had the right to vote, not that everybody would have the right to vote. That does not strike me as true to our American spirit. S1, the For the People Act, deals with this in a very important way, and I want to be very clear. This legislation would stop this wave of voter suppression cold. It stops it in its tracks. And Congress has the power, the right, the authority, constitutionally and legally, to do this. What this bill would do is set national standards to ensure that every eligible citizen has the freedom to vote and the ability to make that ballot count. It would make automatic voter registration already the law in 19 states, Democratic and Republican states, the law of the land. It would ensure access to vote by mail and early voting and other things that proved so popular and so effective in recent years and are used by tens of millions of people enthusiastically. It would ensure the right to vote be given to returning citizens after they are incarcerated so they can rejoin our society. It would take all these important steps, and I note again that every one of the things in this legislation, every proposal in this legislation is based on a tested and effective reform or policy at the national level, at the state level, and at the local level. It would bolster election security in significant ways, and has been noted, you are more likely to be hit by lightning than to commit voter impersonation in the United States. We can't allow the conspiracy theory about massive misconduct to guide policy. And I will note also that this legislation, in very significant ways, honors the Constitution. The Elections Clause gives Congress this power, and I would note as well that the Supreme Court of the United States in 2019, in an opinion by John Roberts, specifically pointed to this legislation as a constitutionally sound example of Congress's power to set election law. This is part of the great story of American democracy. Will we live up to our best ideals? Will we build a multiracial democracy that really represents all people? Or will we allow a drive to take place to turn the clock back, to cut back on those rights? This legislation would be a significant and, again, long overdue milestone for our country, and I urge you to enact it.
Thank you very much, Mr. Waldman. Thank you to all of our witnesses. I'll begin the questioning and then turn it over to Senator Blunt. I did want to clarify one thing. I've been hearing the word chaos tossed around. Well, let me tell you what chaos is. Chaos is what we've seen in the last few years, 5-hour, 6-hour lines in states like Arizona to vote. Chaos is purging names of longtime voters from a voter list so they can't go vote in states like Georgia. Chaos is a state of Texas declaring that you can only have one drop-off box for votes and ballots in their state, including huge counties like Harris County with nearly 5 million people. Chaos is forcing people in Wisconsin to stand in garbage bags in the rain, waiting in line just to exercise their right to vote. Chaos is people in South Carolina being told that they have to have a notary public to be able to get a mail-in ballot and having to have it do it through a window of a hospital while they've got COVID. Chaos is a law in North Carolina that a circuit court ruled was so discriminatory against African Americans that they said, this is a conservative circuit court, that it was designed with surgical precision, their words, not mine, to discriminate against African Americans. And chaos is what we saw happen at the Capitol when people heard for an entire year that our election isn't sound, and they decided to come here and take it under their own hands. That angry mob, that was chaos. And what this bill tries to do is to simply make it easier for people to vote and take the best practices that what we've seen across